Woo! Ding dong. We're on. Okay, so it's Monday, December 18th, and we are reading The Art of Passing the Buck, Volume 2. We're going to start in Chapter 5, which is page 74 on the PDF, but really page 49 in the book. But since everyone's looking on the PDF, look for that. So, also we are, wait, what was I going to say to you guys? Crap. Holy moly. I just did a brain fart. Oh, that's right. So Howard, is going to be coming on for Q&A January 8th. So what I want to do is, for those who have questions, I would like for you to possibly write them down and send them to me. I want to make sure we're not asking duplicate questions or simple questions that may already be able to be answered in Volume 1. Obviously, Volume 2, we're not done with it yet. But I just kind of want to make sure, and he's literally just coming here to answer questions. Though he is a paralegal, these are just opinions of his. By no means is this to be taken as legal advice. But it will be a good opportunity, especially for those who are like chomping at the bit to do a trust. It might be a good time for you to ask whatever questions you might have, either about the book or about creating a trust or things revolving around trusts. So, yeah. And with that, I will go ahead and start. Everybody got Chapter 5 up and ready? Okay. Here we go. Chapter 5, The Will, the Way, and the Intent. A declaration of trust or any derivative or combination of terms using the word indenture or trust changes the lives of many. Because of the long-term effects of decisions and actions resulting from setting up a trust, take time to think carefully through the details, as well as consult with experienced people in this arena. In this chapter, we will look at the multifaceted nature of an irrevocable trust indenture. Besides the differences about trust capital units in a common law trust, the other main departure between a statutory and common law trusts lie in the extensive tax considerations. These are often noted as a statutory trust indenture. In the following outline of a trust indenture, the focus is on the trustee's responsibilities to the beneficiaries and the power of the trustees. As we did in Volume 1, we refer only to tax matters, but do not provide a lengthy discourse nor any advice. This is not our focus. This information provides a place of comparison for those interested in the statutory trust. Essential elements of a trust indenture. The trust indenture is the key to a trust. The more information, the less confusion, and clearer for trustees to know what to do. And if a judge needs to decide elements of the trust, it should be easy. You might wonder what involvement a judge might have in a trust matter. There are sometimes disputes about the wording in the indenture and intent of the grantor. For example, the Hearst Family Trust beneficiaries challenged the trustees 3 important times. And that footnote says William R. Hearst II versus Randall A. Hearst as co-trustee. Yeah, it just gave the things for the court cases. Because Randolph Hearst's wishes are clear, the beneficiaries failed in their attempts. This trust serves as an example in this chapter about some standard elements of a trust indenture. Suggested subjects to be included in all trust indentures. One is the name of the grantor, the name of the trust, and the state. This is the situs location. In a scam trust, the grantor may not be an interested party in the trust. That he or she may be a stranger contributing nothing to the trust, known as a strawman trust. It lacks beneficiaries and a true motive for its existence. In the real world, the grantor is the one who has genuine concern for the beneficiaries, and the beneficiaries have ties to the grantor. 2, the grantor must declare his or her intent for creating the trust. By providing the cash flow of the trust, he or she confirms the trust. This act affects generations to come and supports any other ambitions the grantor has. Setting up a trust for tax purposes merely opens the door for its dissolution in the future. Okay, footnote is just Starkman versus Starkman. 2D, civil number, yada, yada. Okay. The fact came to light when the heir to the UPS fortune put his assets into an irrevocable trust. When he wanted a divorce, he also wanted to disband the trust. Because the indenture focused mainly on taxes, the trust was dissolved. In the Hearst family trust indenture, the instructions to the trustees needed them to make long-term investment decisions, which might incur to the benefit of remainder beneficiaries at the expense of the current income beneficiaries. This was to perpetuate the Hearst media empire. This was so clearly stated in the Hearst family trust documents that challenges to how distributions were handled failed. 3, a longer list of purposes to set up a trust may include to provide liability, protection, privacy, and asset protection from the unwarranted creditors, to prevent the dispensation of wealth, to provide for and encourage wise stewardship of that which has before been entrusted by the grantor to the trustees or trustee. Okay, now we have bullet point number 4. A no contest clause states that a beneficiary who challenges a trust can or will be disinherited. In California, and probably in other states, the beneficiary has a right for judicial review before lodging a complaint to see if his or her challenge violates the no contest clause. In the Hearst Family Trust, the beneficiaries complained that interest earned on their share was not enough and the trustees should get them a better yield. Because Randolph Hearst plainly stated in the trust indenture the trustees had discretion to perpetuate the media empire, this proposal did challenge the no contest clause. It would cause the beneficiaries to be disinherited. They eventually ended their pursuit of this idea. The many beneficiaries needed to be happy with 1.14% of $1 billion. 5, a description of initial corpus to set up the trust organization. This includes the first trustee's acceptance of the initial corpus, which sets the baseline between income and principal. Trustees can judge income as principal if the corpus of the trust is less than when first fixed. A description of what types of assets are to be accepted into an irrevocable trust from other people, usually family members. 5, I think. 1, 2, 3, 4, 5. 6 is for a common law trust. A statement declaring the trust is created under private contract. A definition of jurisdiction clarifies under what laws the trust performs. For those legally inclined, this can be included statements about commerce as it applies to the Buck Act. Ooh, Buck Act, yeah. So, footnote is Buck Act at 4 USC sections 105 through 110 D and E, respectively, and jurisdiction over federal areas within states report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within States, unquote, submitted to the Attorney General and President Eisenhower. Okay, yeah, that's another one I have to read is the Buck Act. Okay, 7, a statement about irrevocability. It must include the grantor is clear that he or she gives up their assets willingly and with full knowledge of the results and knows what he or she is doing. The grantor needs to have completed his or her own research or spoken to others not involved in the paperwork before setting up the trust. We are aware that this declaration is included in some statutory trusts. 8, I believe. Retained power, if any, of the grantor for building up the assets of the trust. This has been covered in Volume 1. The next bullet point, I think that's 9. Governing instruments should mention minutes to define and expand the original purpose of the grantor. For a statutory trust, there may be a statement about addenda. Next bullet point, a paragraph stating domicile, which is the same as trust situs, yet so stated within a paragraph. Domicile becomes a major legal issue when, in the future of the trust, assets become spread across different states or even other countries, and beneficiaries as well as trustees live in distant locations. The trust indenture can dictate that all matters must be settled under the laws of a particular state, or there can be a detail about how to handle separate issues. Usually, real estate issues within a trust are settled in the state where the real estate is located, unless otherwise noted. Next bullet point, life or duration of the trust organization. To be a contract, it must have an end date. For a common law trust, it is usually 21 to 25 years. The trust indenture can include a statement the trust is renewable and how to handle renewing the contract. For statutory trust, the indenture includes a statement about when the trust ends in reference to generations. The last generation to receive the disbursement is known as remainderman. When the trust ends, the remaindermen receive the corpus in reference to their present age or percent age. Next bullet point, the power to terminate the trust needs to include as many events as possible regarding when termination of the contract is and is not allowed. Most common reasons are when the corpus falls below a certain value, if the beneficiaries cannot agree and cause endless problems for the trustees, other sound legal reasons as may occur that cannot be foreseen in the present political or social environment. It states in some trust indentures, if the beneficiaries cannot agree and cause seemingly never-ending trouble, then all the funds of the trust shall be given to a particular charity. This usually cools hotheads in the group. Next bullet point. Personnel allowed to act for the trust and their duties and responsibilities. Mention the following whether or not they will ever be hired. Always assume in 2 generations the trust spills over with riches. Include a brief description of duties. State if these people can have a trust custodial account. If they have the power to sign checks, whether there need to be 2 signatures, and if one signature should be a trustee or both signatures be a trustee. This includes general manager, executive secretary, treasurer, steward, caretakers, or co-trustees can also be a secondary signer. Next bullet point, protector duties. As time goes forward, these responsibilities can become extensive. As mentioned before, we devote an entire chapter to the protector and will go into greater detail then. Here is an outline. The trust indenture should cover a description of the following matters. He or she is appointed by the grantor. Handling issues of mediation and arbitration for all trust members about trust business and personal interaction with one another within the trust group or with any matters that affect the group. Protect the present and contingent distribution rights of the trust certificate holders. Succession format. Powers of the protector is dismiss trustee for violation of trust indenture or bringing dishonor to the trust. Right to challenge characteristics of the trust that could expose the assets. Right to review salaries, fees, percentages, and to make changes to be in alignment with cash flow. The right to ask for an audit. Limits of the protector, process of the removal of a trustee, process for the removal of a protector, and investigations of trust activities. Those all are different kind of bullet points unto themselves under protector duties. Okay, reasons for removal or change of status of a beneficiary is one bullet point. The next bullet point is Board of Trustees. Okay, under Board of Trustees, it says voting. For example, if more than one trustee, decisions must be unanimous. If more than 3 trustees, decisions need 2/3 agreement. If a member of the Board of Trustees objects to the decision and does not want to be part of the long-term results, he or she can write a letter to the Board of Trustees to exclude himself or herself from the matter. Another point is description of qualifications of a trustee. This includes educational and business background, as well as religious, educational, racial, and other preferences. Any reference to racial preferences, though, cannot be for derogatory reasons. For example, the indenture can state there must be no less than 2 trustees from India because of the extensive land holdings in India. Another thing under Board of Trustees is a statement about court-appointed trustees. In a common law trust, it states trustees are not court-appointed. Because of this, a delayed procedure outlines what happens if trustees and successor trustees are not available or not performing before a court gets involved. In a statutory trust, the successor trustees may or may not be court-appointed. Powers of appointment of other trustees. In a common law trust, the first trustee usually has the power of appointment, or 2/3 of the trustees do if there are more than 2 trustees. In a statutory trust, if the successor trustees are not available, then a stranger to the trust may be court-appointed. Who cannot be a trustee? Sometimes the grantor specifically does not want certain types of people as trustees, or only a particular religious or educational background qualifies. The trustees and the protector need to understand the reasoning for the preference. Therefore, include a statement about the restriction or the preference. Next bullet point is power of attorney. Under what circumstances can it be used? In some trust indentures, the trustee has an unlimited power of attorney. This means he or she can walk away leaving the trust in the hands of anyone. What are the limits? We suggest the trustees be limited in time and what trustees can and cannot delegate. Next bullet point, trustee responsibilities and restraints. Duties and limited liability of the trustees. This is a standard section outlining that a trustee is not personally liable for trust events and actions. Trustee liability for negligence. This refers to not adhering to the trust indenture and includes matters such as addictive habits that prohibit performing the trustee's duties. Business of the trust. This section describes permissible trust business activities. For example, does the grantor only want the trustees involved in real estate? In our example of the Hearst Family Trust, the trustees must perpetuate the media empire. Next bullet point, power to deal with the trust organization properly. Under this, you have, does this include mortgages, development, startup businesses? The grantor needs to specify these matters. Next bullet point, power to borrow and lend from financial institutions. Under this, it says, are there any limits? Some suggest that a mortgage can be no more than 2/3 of the value of the property. Name the reasons for borrowing. Next bullet point, obligations to the grantor. Under this, the grantor is one of the priorities of the trustees. In some trust indentures, it is believed the grantor gave up his assets for the benefit of others. I think they screwed up there. Does this mean the Board of Trustees neglects him or her? What extras can the grantor get, for example, in his or her old age? Because of the trust laws, there is a matter termed revisionary interest, which can complicit what the trustees can provide and what they cannot provide to the grantor. In this light, we never suggest all the grantor's assets be placed into a trust. The grantor needs a separate pool of funds independent from the trustee's decisions. All right, does anybody have any questions thus far about what I've read? Okay. Next bullet point, trust capital units. This section refers to common law trust only. All right, how many issued? Because the trust capital units can be divided and thus multiplied, it is not necessary to start out with more than 500 to 1,000 TCUs. How are they managed? The TCUs cannot be traded between members of the trust group, nor can they be pledged to third parties. They must be cashed out only through the Board of Trustees or traded back to the Board of Trustees to be reissued to other beneficiaries. Who can inherit them? Usually the children, as referred to as, quote, issue of the body, unquote, of the grantor, and their descendants are the ones eligible to inherit TCUs. This is where all those, quote, what ifs, decisions are made. What if the first generation beneficiaries do not have children? Who then gets the TCUs? Trustees hold TCUs while they serve, but not being of the bloodline may not pass them to their heirs. While the grantor is alive, the adverse trustee cannot be a beneficiary. Yet once the grantor passes, any of the qualified beneficiaries can become a trustee and hold the majority of trust capital units, thus becoming the adverse trustee. To gain this position, though, the current adverse trustee must allow it. Rules and procedures for inheritance of TCUs. If a direct descendant becomes incompetent, gets into trouble with the law, or there are other complications, how should the trustee handle the distribution? Can TCUs be exchanged with other trusts and organizations? Usually this is assumed unless limited in the indenture. Next bullet point. Financial conduct. Accounting What are considered trust expenses and what will the trust not reimburse or pay for? Distribution or disbursement. How often should it take place? Are the trustees to distribute all of the profit? Charitable contribution. What charities should be supported? Who in the trust group should be responsible for charitable donations? Next bullet point, procedures. Meetings. How often? Recording names of trustees. In the original capacity of the trust, the executive secretary is responsible to make available the names of the trustees. Third parties relying on actions by the trustees. This is to ensure that sellers are paid by the trust and the trust is responsible, not the trustees personally. Privacy. A statement about the privacy of the trust. This may or may not apply to a statutory trust. Dispute resolution. How is it to be handled? This can be included in the section for the protector. Next bullet point, copies as originals, or copies as original. Next bullet point, definition of terms. Next bullet point, severability clause. Under that it says, now that we filled you in on the basis or basics, here is how it plays out in real life. All right. Anybody have questions thus far regarding that?
I do.
Yeah.
Okay, so I got a little confused because I was under the impression that an adverse trustee cannot be related. But then they were saying in the reading that a beneficiary can become an adverse trustee if the grantor dies.
Right. Okay. So while the grantor is alive, the adverse trustee cannot be a beneficiary. Yet once the grantor passes, any of the qualified beneficiaries can become a trustee and hold the majority of trust capital units, thus becoming the adverse trustee.
Okay, they said qualified, so okay.
Okay. Okay, yeah, they didn't specify what qualified meant, but I'm assuming because the grantor is the one that the beneficiaries are related to, once the grantor dies, any of those beneficiaries that are qualified to become an adverse trustee can then become the trustee because they no longer have a family relation per se, because the grantor is pretty much dead. So now someone else has to step up and possibly become the adverse trustee. Did I say that right? Because the adverse trustee is between the grantor and the beneficiary, or is a connection between the grantor and the beneficiary. That's what makes them not able, if they're a family, that's what makes them not able to be an adverse trustee. But once the grantor is dead, then there's nothing stopping them from becoming an adverse trustee anymore.
Well, I was under the impression that my understanding is when I read about the adverse trustee, the reason they don't want that trustee to be related is because that trustee can be more objective with family matters, siblings, whatever.
Right. Okay.
That's a question for Howard.
Right. There you go. An adverse party is defined as any person having a substantial beneficial interest in a trust, which would be adversely affected by the exercise or non-exercise of a power which he possesses respecting the trust. Oh, this one says ordinarily a beneficiary will be an adverse party, but if his right to share in the income or corpus of a trust is limited to only a part, he may be an adverse party only as to that part. Thus, if A, B, C, and D are equal income beneficiaries of a trust and the grantor can revoke with A's consent, the grantor is treated as the owner of a portion which represents 3/4 of the trust, and items of income deduction and credit attributably in that portion are included in determining the tax of the grantor. All right. So yeah, mark that down for a question. Okay. Anybody else want to bring something up? Okay. Creditors and IRS liens. If a trust is not written correctly, it can become subject to an IRS lien. In an article appearing in the Los Angeles Daily Journal in April of 2006, which Bruce Givner, poorly drafted trust, could be subject to IRS lien. Daily Journal, okay. Several factors must be included in a trust document. Some of these factors dovetail neatly with much of what has been discussed. Here are a few excerpts from the article. First bullet point. Property given to a child is subject to the child's creditors. Instead, transfer the property to a trust for the child's benefit. The trust must contain a spendthrift provision. Next bullet point. The trust gives the trustee complete discretion as to distribution of principal and income. Next bullet point. A creditor can get only a portion of what is distributed to the child, and a judge cannot force the trustee to make distributions. The trustee can determine that the beneficiary needs all the distributions to maintain the beneficiary's standard of living, and the creditor will get nothing. Next bullet point. Judges and creditors cannot force disbursements from a discretionary spendthrift trust to satisfy a beneficiary's obligations. Okay. And those two footnotes, they were referring to a California probate code. Next bullet point is the IRS can seize all mandatory trust payments. The IRS may levy upon the taxpayer's property, including trust payments and future payments. In other words, if the trust is written that an annual payment must be made to the beneficiary, then if the beneficiary has a tax lien, the IRS may seize the funds to the beneficiary year after year until the payment is satisfied. Spendthrift clauses. This clause prevents most creditors from attaching the trust. A suggested spendthrift clause is as follows. No interest of any beneficiary shall be subject to sale, assignment, hypothecation, or transfer of any beneficiary other than in the exercise of an appointment power given to the beneficiary, nor shall the principal of any trust or its income be liable for any beneficiary's debt or to the process of any court in aid of execution of any judgment so rendered. The summary to this chapter is, throughout Volume 1, we emphasize the impact on the family when a trust becomes operational. Because writing a trust changes the lives of many, take time to think carefully through the details as well as consult with people experienced in this arena. In this chapter, we looked at the multifaceted nature of an irrevocable trust indenture. Besides the differences about trust capital units in a common law trust, the other main departure between a statutory trust and a common law trust lies in the tax considerations. These are often noted in a statutory trust indenture. In the outline of a trust indenture in this chapter, the focus is on the trustee's responsibilities to the beneficiaries and the power of the trustees. As we did in Volume 1, we refer only to tax matters, but do not provide a lengthy discourse nor any advice. This is not our focus. We do not suppose that we have addressed all the matters to include in a trust indenture, but this gives a grantor a good start on the subject. Often, other subjects surface, such as the care of those less fortunate family members who may have debilities and the issue of their caretakers. All right. On to chapter 6, unless we got questions. Nothing? Okay. All right, chapter 6, Loading the Power. In Volume 1, Chapter 11, we explain the criteria to decide whether an asset is suitable for your trust. Here, we focus on the protocols for getting an asset out of your name and into the name of the trust. Whether or not you are the grantor placing assets into a trust, we now refer you as the exchanger. Assets placed in a statutory trust have no exchangers, since they are referred to as transferees. For simplicity in this chapter, though, we use solely the term exchanger, although there is an important difference between the two terms. We also use the term transfer in this chapter. Paperwork to get assets into a trust transfers assets into the trust. The term exchange, quote unquote, refers to paperwork within the trust. Therefore, an automobile, for example, is transferred into the trust name at the Department of Motor Vehicles, yet exchanged into the trust for trust capital units. According to the court case of American National Bank of St. Joseph versus United States, property received in exchange for another property has no fair market value. Without a value, there is no taxable basis. This is why funds placed in an irrevocable statutory trust are a gift or a taxable event if the amount exceeds the gift limit. The assets are transferred, not exchanged. We assume you determined, based on the previous criteria, exactly what you consider an asset. Because each is handled differently, we divide assets into 5 basic categories: real estate, intellectual property, financial, collections, and vehicles. The objective is for you not to be responsible for the maintenance, management, or tax liability of the asset. Proper execution of the transfer documents marks a clean break from you and a concomitant acceptance of responsibility by the Board of Trustees. Changing the title sets the new ownership. Okay. Exchangers. Accompanying the paperwork created by the exchange is a letter to the Board of Trustees from the exchanger explaining the following. 1. The purpose of placing assets into the trust for specific reasons by the exchanger. 2. The market value of the asset at the time of the exchange to provide a record that may be needed solely for tax purposes later. 3. Names of the beneficiaries. 4. Specific instructions about the asset, if applicable. In a common law trust, the letter includes a statement requesting trust capital units in exchange for the asset. The Board of Trustees reviews the offer and either approves or rejects it. Real estate. All property is recorded at the county recorder's office to fix its boundaries, assess its value, and establish the yearly taxes. This real estate currently exists under the name of the exchanger, who can give it away to his or her family or give it to anyone. If given to other than the family or family trust, there are likely to be transfer taxes, sales taxes, or some other fees involved. When selling the real estate, the buyer pays these fees. Countries have become more particular about to whom property can be transferred. Sometimes, to ensure the property placed into a family trust is legitimate, the county requests the name of a beneficiary who must be related to the exchanger, otherwise the fees may apply. As noted in Volume 1, this is a direct challenge to trust privacy. Sorry, I had to yawn. Use a standard format deed of conveyance or a warranty deed to transfer the property. This document may be complex or simple, depending on the preferred style of the people involved in creating it. Because it transfers into a trust, we prefer a more formal document. There are standard forms available at the county recorder's office, downloadable from the internet or from a paralegal. The wording needs to address a trust status. A more formal deed of conveyance, for example, will have the following parts to it. First bullet point, the name of the exchanger and their address. The name of the trust with the names of the trustees, the address of the trust into which the property is transferred, and what is being conveyed. For example, real property and state and county. Next bullet point. If the property is mortgaged, state the equity transfers into the trust, and the grantor releases to the trust its heirs and assigns forever all of that certain lot, piece, or parcel of land described. Next bullet point. Surveyor's description of the property, usually taken from the previous deed. Next bullet point. A statement that all the rights of the grantor in this premises with any other buildings, improvements, hereditaments, etc. are also being transferred. Next bullet point. If the property is mortgaged, then the conveyance is subject to mortgages listed on attached exhibits or schedules. Include their specific reference designation. Next bullet point. An acknowledgement the trustees have the right and responsibility of the property. Next bullet point, statement of covenant. The trust will quietly enjoy the premises. The premises are free from encumbrances, and the grantor forever warrants the title. Last bullet point, any mineral rights, if not listed, they may be lost to the new deed holder. Some prefer to use a warranty deed if there is no mortgage. The warranty deed follows the same basic outline without mention of mortgages. We have seen property transferred with only the property description and one sentence stating the name of the seller and the buyer. The grantor/exchanger signs this new deed in the presence of a notary before mailing it or taking it to the county. It is best to find any other documents needed by the county. There can be a property value form to complete or a 2-page declaration. The form often needs a detailed description of the physical characteristics and mortgage information. After the trustees and maybe the grantor-exchanger complete these other forms, mail the deed or take it to the county recorder's office. After a month or two, the deed comes back, usually without the added paperwork, to the trust address, either stamped or with the time and date indicator and recorder number in the trust name. County formats and preferences. Sometimes the county wants its particular paperwork in a specific format or needs certain data included. Many counties prefer 1-inch margins. Some counties need a value even if it is 0. It is not uncommon to do the paperwork repeatedly to get it properly recorded. Carefully read any county instructions proper to preparing the deed. I think that meant prior to preparing the deed. This usually saves time, but because each county is different, there is no way to predict what will work and what will not work. Once recorded in the trust name, the trustees are responsible to preserve the property and are liable for the taxes. The trustees take responsibility for maintenance and repairs, and only they can sell the property. The issue of whether the grantor exchanger remains living on the property becomes a matter of debate. The easiest way to satisfy the taxing agencies is to have the exchanger pay rent as long as the exchanger lives in the property. Of course, these added funds to the trust are to improve the property for the beneficiaries, so this works well for the trust. Rental property notification. Notification of transfer of ownership. If a management company collects rent, once the transfer deed naming the trust as owner is filled in the county and a stamped copy is returned to the trustees, a photocopy of it is sent to the management company. Along with a cover letter from the exchanger giving instructions that payments are now addressed to the trust. Tenants. The paperwork to change rental payments to the trust is through a formal letter to the tenants from whomever they previously paid rent. You need not give a lengthy explanation. Simply direct them to make checks out to a different name and give them the address and phone number. Mortgage. Sometimes it is necessary to mortgage the property. Who has the best credit rating and the trust property determines how this is done. If the grantor is still alive and he or she has the strongest credit rating, the property can be transferred back into the grantor's name for the time to get the mortgage, then transferred back into the trust, and the trust pays off the mortgage. Oh, dang it, I'm getting hit by yawning fits. If the grantor is no longer alive, then trustees handle this responsibility, and it depends on the trustee's credit rating and how much money is in the trust. Banks usually do not loan money to a trust unless the trust has substantial assets the bank can lien. In rare cases, if the real estate is owned outright by the trust, the trustees in the name of the trust may obtain a loan directly for the trust. This applies when the amount borrowed is for less than the property value. Bankruptcy time clock. Property must be in a trust more than 18 months to be exempt from bankruptcy, and in some instances, it is 3 years, depending on the state. For example, property in trust for 4 years or more cannot be considered part of the grantor's property. The clock starts over if the property is taken out of trust, put back into the grantor's name, and then put back into the trust. Okay, so that one follows along the lines that if the grantor's credit rating is really good and the property can then go back to the grantor for him to get the mortgage and then go back into the trust, that clock starts over again. With this bankruptcy time clock. Anybody else have questions or comments? All right. And y'all know that you can just unmute and stop me at any point if you do have a question.
I could take over the reading.
Okay, great.
I tried to do it when you first started, but I couldn't get to the mute button too quick enough. All right. So intellectual property. Sometimes the transfer of intellectual property becomes complicated and sometimes easier. If not registered, create an assignment to the trust. Notarize the assignment and give it to the trustees. The transfer assignment states from whom, the item description, value, and to whom. And then that's followed by a footnote. Copyright.
Oh, wait. Hold up.
You want to read it?
Yeah, because it's see Appendix B, sample format 9. So hang on, because I bookmarked all of these appendixes.
Okay.
I got marked from the last time because it took forever to find. What'd they say? Sample what? Sample 9?
Format, yep. Format 9. Mm-hmm. Under Appendix B.
Appendix B, format 7. Format 9. Okay. So hang on, I'm gonna share screen. Okay. Sample format 9, transferring collections. For everything going into a trust, we need, let me do that. We need to ensure the grantor legally places the item in trust. Although many of the assets found in a collection category or a miscellaneous category remain with the grantor until he or she passes, these items need clear identification. Sometimes would-be heirs hover in anticipation of the goodies left when the grantor dies. Assets of this nature in trust need to be collected prior to the grantor's passing, if at all possible, to remove them from confusion of items listed in a pour-over will, where assets may be earmarked for specific people. This format is adapted from a standard legal assignment of assets to a corporation. Reference to TCUs has been added and may not be necessary, as this private information and the assignment of assets may be needed to prove ownership in the future. Others should not know about TCUs. Because inventoried items are listed in Appendix I, we omit them here. Further, Appendix H, sample format 39, gives another example of assignment of assets. Okay, assignment of assets, Clarence E. Day Trust. I, Carol E. Haverson, reside at 288 Eastern Lauren Avenue, Unit 5, Santa Maria, California, blah, blah, blah. And I hereby exchange jewelry for capital trust units in Terrence E. Day Trust, created on June 15th, 2000, whose address is yada yada. The trustee of Terrence E. Day Trust are Nora M. Swath and Kent M. Richards. The current value of this asset is approximately $65,000. The attached schedules A, B, and C give further details. Be it further known, for value received, I, Carol E. Haverson, hereby unconditionally and irrevocably assign and exchange into Clarence E. Day Trust all rights, title, and interest in and to the jewelry as shown on the attached schedules heretofore referenced. I, Caroline E. Haverson, fully warrant that I have full rights and authority to enter into this assignment, and that the rights and benefits assigned hereunder are free and clear of any lien, encumbrance, adverse claim, or interest by any third party. And then it has, the assignment shall be binding upon and inure to the benefit of Terrence E. Day Trust and its successors and assigns, in confirmation of agreements and commitments made June 15, 2000. Then you date it, you sign it, and then you get it notarized. Okay. Continue.
All right, so copyrights. If the document has a copyright, fill out a new copyright. There is a section on the copyright form titled Transfer. State the transfer reason. Any trust documentation applicable to the transfer probably should go with the new copyright to meet any legal considerations. and that's followed by a footnote of 34. You want to read that one?
Is sample 10. Right, hold on. Okay, B and sample 10. That wasn't it. Oh, maybe that was it. Okay. All right, it says for sample format 10, copyright transfer, the sample documents are taken from Niemer on copyright, the authority on this subject. Adapted from suggested formats, we present the following copyright assignment and bill of sale. The procedure to transfer a copyright is more complicated than presented here. It begins with a letter outlining the reason for the exchange into the trust, the names of the beneficiaries for whom this exchange is made, the number of trust capital units given in exchange, the value, and contact information for the exchanger. After the letter is received from the exchanger, minutes need to be created approving the exchange. See Appendix H for further details. There are several pages to be reviewed about this procedure, including obtaining a document cover sheet. We refer you to the Copyright Office for further details. The forms presented here, though, will give you a good foundation for getting a copyright into your trust. So, share screen again. Okay, so copyright assignment, short form for individual. Individuals, for and in consideration of the sum of $21 in silver coin and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, name, author, seller, hereby irrevocably grants, conveys, assigns, and sets over to name trust, purchaser, and its successors, and assigns all of the seller's right, title, and interest in and to the book titled book name. This assignment pertains to all the assets, properties, receivables, contracts, and rights thereto, all as more fully set forth in that certain bill of sale, Schedule A, dated as a blah blah, executed by the purchaser, and any contracts pertaining to the publication of book name in reference to commissions due or expenses. The undersigned executed this assignment on blah, yada, yada, yada. Okay. All right, you can continue.
Okay. Patents. Wait a minute. Okay. Patents. To transfer a patent to the trust, follow these instructions. To apply for a patent under 35 U.S.C. 111, transfer the ownership of a patent or request other actions related to patents, certain information specified in the patent laws, Title 35, United States Code, and rules, Title 37, Code of Federal Regulations, must be submitted to the U.S. Patent and Trademark Office, the USPTO. Complete details on patent procedures, rules, and regulations, together with the relevant forms, are available at the United States Patent and Trademark Office. Financial instruments. This includes anything from bank debentures to promissory notes. Let me get to the next page. Okay. When there's a recording of the name of the exchanger located in any official capacity, that recording needs a formal change of name. Most financial organizations have detailed paperwork to make the transfer. The exchanger fills out the paperwork from the financial institution and signs it. Then the trustees sign in the appropriate space. Often the trust name, address, and EIN are needed. Any changes to the account then come through the trustees only. Promissory notes are usually not officially recorded. There's an assignment portion of the promissory note for the exchanger to fill out, so funds he or she has been receiving go directly into the trust. Give a notice of the new assignment to the debtors to redirect their payment to the trust. Cash and banking. Cash opens the bank account, preferably in the form of a check. A respectable amount of $1,000. Eyes light up when the amount is $10,000 or more. The more money there is to put into the new checking account, the more likely the account gets opened. One trustee only opened accounts with $50,000 or more. He said banks never turn it down. That was before the Patriot Act. Now cash transactions of $10,000 or more are red flagged. Not all trusts have $50,000 to toss into a bank account. With fewer funds, the banking adventure varies. Often, the banking experience is where the trustees get their first fiduciary on-the-job training. Different banks have different policies. Some like trust accounts. Others will not open them. Some will only open living trust accounts, while others open irrevocable trust accounts. Private trusts are not a problem with some banks, while others shy away. Trustees need to set aside one day to go bank shopping. Even experienced trustees sometimes need to go to 3 banks before they find an agreeable banker. We had trust paperwork presented to legal departments that rejected it, while the same paperwork was praised by other banks. Further, a different bank with branches opened a bank account in one branch while the other turned it down. Since most of our experience is with the irrevocable common law trust, you might think it has to do with that aspect. But the paperwork to open a bank account is distilled from the best in the statutory world. Let me get to the next page. Okay. Lately, banks have decided not to take responsibility for 2 signature accounts. We tell them it does not matter because we take responsibility for it. And that's followed by a footnote. You want to read that one?
Appendix F.
I believe so. Let me go there and see. Because I can't see. My screen is really big. Yep,
Okay.
sample format 26.
Okay, sample format 26. Okay, so that was 26 right there.
Yeah, it was format 36.
The meeting, and it's for minutes of the trustee meeting about banks, right?
Yes. It talks about the responsibility and 2 signature accounts. I don't know if it's talking about the minutes.
So let me share the screen. Okay, so minutes of the trustee meeting of Allen J. Family Trust. Got the date, the location, the subject is a banking resolution regarding update of banking paperwork, change of signatures, checking account number, and Jackson Olson Federal Bank. The Board of Trustees convened on this date. The following were present and represented a quorum: Darren, Karen, George, Joseph, and Terry. A discussion ensued concerning the banking policy of Allen J. Family Trust. It was resolved Terry Baker, the account manager, is added to the signature card at the Jackson Olson Federal Bank. It was further resolved that Darren Portinkin and Karen Rosencroft, trustees of Allen J. Family Trust, are herein fully authorized by the Board of Trustees to select and make application to any bank or financial institution for the purpose of establishing one or more checking and or savings accounts in the name of this organization. The trustees are authorized to make deposits, withdrawals, write checks, investment transactions, and maintain such accounts without further action of the Board of Trustees. It was also resolved the bank or financial institution is hereby authorized to pay out the funds of this organization as directed by the authorized signatures without further authorization from the Board of Trustees. Whether such directives call for disbursements in cash to the bearer or to the order of any third party. After further discussion, it was resolved that a member so named herein of the Board of Trustees is hereby authorized to open merchant accounts. The Board of Trustees may from time to time borrow money from financial institutions for or on behalf of the Allen J. Family Trust. Only when such application is ratified by current resolution of the majority of the Board of Trustees of the Trust shall such borrowing be authorized. The loan duration, interest rate, terms, and conditions may be what the Board, having such authorization, deems expedient. Evidence of such indebtedness is created by executing and delivering in the name of and on behalf of this trust a promissory note, a judgment, promissory note, or other like obligations of the trust, signed in the name of this trust by the authorized signatures designated below. The Board is authorized to secure loans with trust property only per the terms of the trust indenture. The tax EIN number is that. The following people are authorized to sign checks or withdrawals from any accounts created with the selected banks or institutions, with 2 signatures being required. One must be a trustee. See how they incorporated that right in there? And then they had their 4 names down. And this banking resolution shall remain in full force and effect unless or until canceled or modified by the Board of Trustees. If any changes affect any banking and or investment arrangements, an updated copy of the banking resolution will be presented to the bank. And then you've got the trustees, the secretary, alternate for 1 signature on checking account. Some banks will not accept documents on which 2 signatures are required. The following has been successfully used. Insert after the tax EIN is whatever it is, put in the EIN number. Mr. Trustee's name stated that name of bank will not accept responsibility for 2 signatures, and it is in the declaration of indenture that 2 signatures are required on all financial documents. After further discussion, it was resolved for the purpose of the name of the bank, 1 signature is required on all financial transactions. It was further resolved that although 1 signature is required on all financial documents for that bank, 2 trustees will sign all financial documents to be in alignment with the name of the trust, declaration of indenture. Name of the bank is not responsible for 2 signatures. It was also resolved that the following number of trustees are authorized to sign checks or withdrawals from any accounts created with that bank. Also, put the name of the bank on the subject line in the banking minutes. Okay, you're good to go.
All right, wonderful. Okay. This is because our trustees know, for their own safety, 2 signatures means they cannot be accused of using funds for themselves. Not that they would, but any added assurances makes them happy. After opening the bank account, establish a good working relationship with the people in the bank. With any changes of trustees, update the banking paperwork. The more money flowing through the account, the more they notice. Your appearance at the bank can just make their day. Do not use familiar banks. To keep trust assets safe, the bank account and all financial accounts should not carry directly over from the grantor. There are some banks that link all accounts together through the Social Security number. This account belongs only to the trust and trustees. The grantor and trustees should not have other accounts on which their name appears at the same bank. Insurance policies. One of the most common assets put into a trust is an insurance policy. The insurance companies all have transfer paperwork available to place policies into a trust. The trust then becomes responsible for paying the premiums. And when the policy cashes out at the death of the insured, the funds come into the trust. Through the instructions left by whomever was originally insured, the trustees distribute or invest the funds. Accepting a life insurance policy into the trust requires recording various facts and instructions in the minutes. Refer to Appendix D, sample format 19, for appropriate and necessary information to include in the minutes. You want to look at that one, Dawn?
Yeah, hang on.
Okay.
Appendix D, what?
Sample 19. Yep, sample format 19.
Where are you? 19? No, 19. Come on, where'd you go, 19? Ah, here we are. Okay. Okay, sample 19, insurance policies. This is a policy and procedure about insurance policies. As you can see, it has been updated several times. When adding an insurance policy to your trust, these are some of the factors to consider and paragraphs to include in minutes. So you got subject, insurance policies, number, that reference, that's doesn't reference anything, but revision, that objective, transfer insurance policies into a holding trust, distribute to board of trustees, date created on blah, July. Okay, policy. Any member of this trust organization can assign a life insurance policy to Allen J. Family Trust. The management holds the policy for the asset holding trust. When the policy pays out, the management trust gives out the funds by specific instructions from the transferor, who can be the grantor or an exchanger. The insurance company identifies the beneficiary as Allen J. Family Trust, which receives the funds and shares them according to the wishes of the grantor or exchanger. Treat the insurance policy as any other asset received into the Allen J. Family Trust. When applicable, use the below listed information to more formally describe in the minutes the details relevant to the Allen J. Family Trust. 1. Ownership of life insurance policies. Any life insurance policy or policies applied for and bought by the trustee or assigned to the Allen J. Family Trust becomes irrevocably vested in the Allen J. Family Trust as the owner and beneficiary. Allen J. Family Trust shares earnings with the beneficiary per the instructions of the grantor or exchangers. Without specific instructions, share funds based on the TCUs owned by each TCU holder. Grantor or any exchangers exchange the policy or policies with other documents necessary to transfer all rights of every kind and ownership to the Allen J. Family Trust. The grantor or any exchangers keep no rights or incidents of ownership in any policy or policies assigned to the Allen J. Family Trust or bought by the trustees. Payment of premiums. The grantor or any exchangers will be under no duty to pay premiums, assessments, or other charges necessary to keep each policy included in the Allen J. Family Trust in force. The trustee will pay the premiums and keep the policies in force so long as the principal of the Allen J. Family Trust is sufficient to do so. The trustees will immediately notify the grantor or exchangers in writing of lack of cash flow to pay the premiums. Either of these parties may then choose to pay them. Trustees' rights in life insurance policies. The trustees for Allen J. Family Trust, acting solely for the beneficiaries, have the rights of an owner. This includes, but not limited to, A, the right to borrow on any policy, B, the right to exchange any policy for another, C, the right to apply dividends to pay premiums, and D, any other right available to the owner of a policy of life insurance. 4. Collection of earnings. On the death of the insured, under any policy held by and payable to the Allen Family Trust, the trustees receive the net earnings and hold them as part of the principal of Allen J. Family Trust. The trustees need not engage in litigation to enforce payment of any policy without indemnification to satisfy resulting expenses. 5. Limit of responsibility of insurance company. Payment and receipt of funds by Allen J. Family Trust relieves the liability of any insurance company which need not take notice of this trust instrument or become involved in any payment. 6. Trustees' responsibility for maturity of life insurance policy. Before the maturity of any life insurance policy held by Allen J. Family Trust, the trustees hold such policy or policies owned by the management trust in safekeeping. The trustees pay premiums due. If Allen J. Family Trust does not have enough available funds, give notice to the exchanger, who then has the choice of paying the premium. Procedure. The policy owner must write a proposal to the Board of Trustees to exchange the policy for trust capital units. The policy owner can specify or add beneficiaries to the asset holding trust in which the policy belongs. If the policy is not an asset holding trust, minutes are created as a guideline to the Board of Trustees about distribution of the policy from the management trust. The policy holder writes a letter to the insurance company transferring the policy to the trust. The insurance company sends the correct transfer paperwork. The trustees go through the formal procedure of accepting the policy and issuing the trust capital units. Example letter is attached. So you got the list of the Board of Trustees. So here would be a letter that one would need to give to the Board of Trustees. So you got agent's name, insurance company, dear agent, transfer of life insurance policy. I, Sandra J. Allen, am now the owner of a life insurance policy with your company labeled as policy number, blah, blah. The insured person on the policy is Sandra J. Allen. I transferred and assigned all my rights, titles, and interests in and to this policy of life insurance to the Allen J. Family Trust, settled on that date. The trustees of that trust unanimously accepted the transfer of the life insurance. They specified 1, the Allen J. Family Trust is the owner of the policy. 2, the Allen J. Family Trust is the sole beneficiary of the policy. 3, pay insurance premiums to Allen J. Family Trust. The names of the trustees are Darren and Karen. Please change your records immediately to reflect this transfer. Send applicable transfer paperwork to my address shown above. Okay, so this doesn't go to the trustees. This goes to the insurance company. Okay. All right, go for it.
Okay. All right. So collectibles. This section covers anything from coin collections to antiques. Collections are more difficult, for the Board of Trustees must keep inventories. The collection is usually not officially recorded at any institution. If the Board of Trustees is willing to take on the responsibility, then the exchanger creates and notarizes an assignment form. This often needs an extensive inventory. Without the inventory, the trust cannot claim the assets. Further, expert appraisals may be needed to establish the collection's value. This is not just for tax purposes, but to ensure proper insurance coverage, as well as establishing the initial corpus. Vehicles. Only owned vehicles, not leased, can be put into a trust. For the trust to take legal possession, fill out a sales slip from the exchanger to the trust. Present it to the Department of Motor Vehicles. The trust pays the sales tax. This keeps the exchanger at arm's length. In some states, the grantor can gift the vehicle to the trust, and there is no tax. Using this method can confuse the title. The easiest way for the trust to get the asset is to pay the sales tax. Vehicles are legally referred to as lethal weapons. Keep them in their own separate trusts with genuine beneficiaries. The insurance policy is for the vehicle and trust, under the name of the trust and the trustees. The beneficiaries have the right to use the vehicle if it is available. Do not put two vehicles in the same trust. Funding. The transfer of assets into the trust often produces a cash flow within 30 days. Usually, it is from the investment account or accounts, or if there is rental property, the rents are now directed to the trust. If the trust cannot produce its own cash flow, then it is a grantor trust and the grantor remains taxable. All irrevocable trusts need to produce their own income without interference from or reliance on others. Management.
Hold on, just right here. Did anybody have any questions about what we just read? Because that was a lot.
Vehicles are classified as lethal weapons. What did it say?
Yeah,
Did you see that?
pretty much.
Legally referred to as lethal weapons. What does that mean?
That is interesting.
I'm sure that's true, but it's like because you could hurt somebody with them or what? I guess.
Yeah, I'm guessing it's because you can definitely kill somebody or maim them or hurt them.
So you need a good insurance policy, I guess.
Well, I find it interesting that they say make a separate trust for each car. I thought you would just put all the cars in one trust, but evidently not.
Well, they must be a serious matter if they need their own, protection or something from the lethal weapon. Oh my gosh, that's crazy. Anyway, I thought that was interesting.
Well, look at what's his name, Ted Kennedy. He ended up killing a girl in a car that was in a trust.
Yep. Yeah. Lethal weapon.
The family couldn't even go after them because they were paupers. They had nothing. Everything was in the trust.
Yeah. Well, there you go. That's an example. Wow. Anyway, that was
anybody else? Nothing? Okay. Go for it. Read on.
Okay. Management of assets. Asset purchases. Use credit cards dedicated to the trust to buy assets. Also, use checks and money orders. Any trust member who buys assets or supplies with personal funds is paid back by the trust. For the trust to use a credit card, one of the trustees needs to apply personally for it. Financial institutions resist giving a credit card to a trust. So paying the credit card is not income to the trustee. The Board of Trustees needs to identify the card and formally take responsibility for its payment within trust minutes or by separate agreement between the cardholder and the Board of Trustees, stating that this is for trust business only and is not income to the trustee. Let me get to the next page. Okay. All right. Trust property identification and approvals. As a trust matures, the number of financial and real estate transactions multiply. At some point, the beneficiary may want to know if an asset has increased or decreased. This may need tracing several transactions. Therefore, the trustees must keep an accurate record of the assets, not only for the beneficiary, but as a historical record. Treat most small purchases of equipment, for example, under $3,000, as office supplies and keep receipts with the account manager. Because of their short life, treat computers as office equipment and not as an asset. They often need upgrading and replacing. They are an expense. Detailed purchases over $5,000 on asset forms include serial numbers, warranty information, and a description clear enough to give the police should it be stolen. Secure an identification tag to the item on which the name of the trust appears with an asset number. Document transactions about real estate in the minutes. Large purchases, for example, over $50,000, need the approval of the Board of Trustees through minutes documenting a general discussion of why the purchase is necessary. Separate trust asset schedules for each trust by asset, separate trust asset schedules for each trust by asset, such as Schedule A is a list of large office equipment. Schedule B is a list of checking accounts and financial institutions. Schedule C documents office furniture. Asset splits because of separation. That's followed by footnote 37.
Yeah, Appendix D, right?
I believe so. Uh-oh. Shoot. Went down too far. Wait a minute. Because I'm on this computer, so. It does. Yep. Appendix D for minutes regarding the TCU splits.
Okay. Think this might be it. Reading minutes, training, no. TCU splits. What the hell?
That may be it. Are those minutes? I think they are the minutes.
I don't, they aren't being really, it needs to be talking about the TCU split. All right, I'm just going to read the action meetings. Let me see if this has anything to do with it. The section shows you how minutes happen, what they are, and how to use them. Minutes sometimes document several telephone conversations in which all trustees participate over a period of 1 or 2 days before a decision is made. The minutes summarize the points considering the state resolutions. All trustees sign acknowledgement their agreement. It is helpful if minutes are written well. Think complex decisions. The minutes become important, especially when they are complex decisions, any multitude. I think I've already read this before, haven't I? It's just the general.
Seems like it.
ECU split. Shredding legally. No, I don't think it has anything about TCU splits.
There's no hyperlink where you could just click it and it takes you right there.
I know, it would be nice. No, that's not it. All right.
Excuse me a minute. This is Anna. On page 386, they have a sample format 20, Trust Capital Units TCU split.
Oh my gosh. So 2 what or 3 what?
386. In the book.
Oh, in the book?
Yes.
386.
But it's sample format 20, it says.
Okay. Yeah, they screwed that one up. All right, thank you.
You're welcome.
Okay, sample format 20, trust capital unit split. Because TCUs were more complicated than other aspects of the trust process, we enclose the minutes as a demonstration of how a 4-to-1 trust capital unit split occurs, giving only a 2-to-1 split to the current TCU holders. So you got the subject, trust capital unit split, TCU issues, Gleason, and Aquilon. The following forming a quorum were presented at the Board of Trustees meeting: Karen, April, Mary, and Jamie. And April was by telephone. Miss Allison pointed out the trust capital register is nearly out of available TCUs. After further discussion, it was resolved that there be a 4-to-1 split, and current trust capital unit holders will receive 2-to-1 for their current TCUs. Miss Allison stated 2 trust certificates have not been issued, even though they have been approved, and she does not know how many TCUs should be issued. After further discussion, it was resolved to issue 15 capital units to Adrian I. Gleason, approved on October 25th, 2004, and issue to Anita Marion Accelon 10 TCUs, approved June 2005. Schedule A shows the additional authorized units to be issued. And then you've got all of the quantity, the TCU number, when it was added, total certificates, and the issue date. So there being no further business to come before the board, the trustees told the executive secretary to enter these proceedings into the trust records, and the meeting was adjourned. And that was it. All right. You good to continue on?
Wonderful. All right. Asset splits because of separation. Separate assets placed in the same trust by an exchanger. He or she may want to move them to another trust or seek a change of management. Also, keep asset lists separate by type so there is no confusion about what assets go where. If not individually tagged, mingled assets cannot be identified. To sort out the confusion, they all may need to be sold and the cash shared. If this happens, then all the TCU holders get a payout. Turning assets into cash. Sometimes it is necessary to sell assets to create more cash or to turn a static asset into a cash flow. For example, if vacant land is not appreciating at a significant rate, it would be better to free the funds to invest in a growing enterprise. Cash from liquidated assets goes into the trust checking account. The Board of Trustees decide if all or part of the funds go to the beneficiaries or are reinvested. There are several other reasons to liquidate. These depend on various circumstances that change from year to year. It may be necessary to dissolve the trust. In the common law trust, the assets belong to the TCU holders per their percentage. Because the trustees hold most of the TCUs, they get the largest payout. This discourages other TCU holders from seeking to close out a trust. Besides that, a trust is the golden goose, producing funds indefinitely. The trust indenture states dollar value of the minimal corpus. If the trust corpus falls below that value, then there is a possibility of ending the trust. When this happens, there usually are not enough funds to distribute. Sometimes, though, The trust has enough funds, but the beneficiaries cannot get along. The trustees decide it is not worth the trouble and cash out investments in property. The TCU holders get their share. In a profitable trust, the IRS gets taxes from K1s submitted by TCU holders. Sometimes, because of complications beyond anyone's wildest dreams, the original corpus needs to be returned. Some of these reasons are trustees place the assets into funds that failed. The exchanger's behavior is intolerable and is not worth dealing with him or her. Unforeseen difficulties cause bankruptcy or other financial problems with the grantor within the first 18 months of the trust. Troubles with agencies, and that's in quotes, of any type disrupt the organization to such an extent it becomes impossible to continue. If the asset has not increased, return it with only documentation. If the asset has increased, the exchanger may need to pay taxes on it. A statement known as a return of original corpus can be notarized by the Board of Trustees. State the original corpus value and the current value. A suggested format is found in the appendix, and that's footnote 38. And that references Appendix B, sample format 11.
Sample 11, yeah, okay. So here's that. Okay, sometimes it is not worth keeping assets because beneficiaries may fight over them or the grantor falls on hard times and desperately needs cash. The trust may have the assets but not be cash rich at the time. In the case of this jewelry inventory, no one may have been willing to take the time to catalog it, and without sufficient descriptions, the trustees cannot prove ownership. The documentation is both for the grantor and the trust to establish ownership. So it's return of assets, Clarence E. Day Trust. We, Nora M. Swath and Kenneth M. Richards, trustees of Terrence E. Day Trust, located at that address, hereby return the jewelry to Caroline E. Haverson and canceled the 25 trust capital units, numbers 015 and 034 in Terrence E. Day Trust, created June 2000. The current value of this asset is approximately $70,000. The attached Schedule A, B, and C give further details. Be it further known, Nora M. Swath and Kenneth M. Richards, as trustees, hereby unconditionally and irrevocably assign and exchange into Carol E. Haverson all rights, title, and interest in and to the jewelry as shown on the attached Schedules A, B, and C, heretofore referenced. We, Nora M. Swath and Kenneth M. Richards, as trustees, fully warrant that we have full rights and authority to enter into this assignment, and that the rights and benefits assigned here under are free and clear of any lien, encumbrance, adverse claim, or interest by any third party. The assignment shall be binding upon the in-year of, or to the benefit of Carol E. Haverson and her successors and assigns. And that's pretty much it.
Wasting assets. A gold mine and timber are two examples of a wasting asset. The more taken out of a mine, the less the mine has to give. This places a lifespan on the asset. The same with timber, unless trees are planted to replace the ones logged. Often, there is a provision in a trust indenture advising the trustees to sell wasting assets before they become unproductive. Excuse me. Of course, this is a judgment call of when that would be. Okay. Another wasting asset is a bank account that does not earn interest, but charges an annual or monthly fee. Placing funds in it can be costly. The famous Swiss bank account falls in this category. Certificate of loss. Take inventory of assets at least every couple of years. It is not unusual to discover something missing. Whether it is stolen or not is unknown, and its location becomes a mystery. Create of a certificate of loss to identify the lost property. This establishes a record that it cannot be found. Unless an item is expensive, it is not necessary to make out a police report. Accounting. Because different asset types are placed in different trusts, this collection of assets can be given to another trust for management or to a corporation. An entity with a checking account takes care of maintenance for whatever is in the asset holding trust. Because of this, the accounting needs to track each asset holding trust individually. This becomes especially valuable if a trust member decides to put personal assets into the trust group. Setting up a holding trust for personal stuff, that's in quotes, allows easier accounting for that set of beneficiaries. While the management remains the same as in the main trust, it can use the same board of trustees to handle the assets by trust. Also, the trustees on the asset holding trusts can be different than those in the management organization. For example, there may be 5 trustees for the management trust, and each one is a trustee on different business trusts or asset holding trusts. The co-trustees can also be mixed among trusts. Residential property is one of the most common uses of a subtrust. Track the expenses for the home and the rental payments separately through management accounting. The management can be through a corporation or other business entity. The holding trust remains a separate trust. For example, if one of the trustees decides to put a stock portfolio into a trust, it gets a separate asset holding trust with named beneficiaries. Although the account is registered under the name of the management organization because it has an EIN and a checking account, keep the internal bookkeeping as a subcategory. In some accounting programs, this is a job classification or job tracking. Residential property in a trust needs financial support. The grantor can no longer pay for the maintenance and repairs. He or she can pay rent while the trust picks up the expenses. Another way is to have an income generating account put into either a management trust or another holding trust. Make the trust holding the residential property a beneficiary. As you can see, with enough of this crossover setup, the organizational format becomes complicated. We provide a diagram in a later chapter. Joint property through marriage. That's a footnote of 39. You want to read that? Or do you want me to finish the sentence? Because there's another footnote shortly after that last comma.
That's just an internal revenue code.
Okay.
But go ahead and finish it, and then I'll finish out with the Appendix J.
Okay. Through marriage, footnote 39, unless the state in which a couple lives has a different set of laws, all assets are either community property or joint property. Footnote 40.
It just says, see also Internal Revenue Code, Part 25, Special Topics, Chapter 18. So go ahead and finish out because you're almost to the end of the book, and then I'll come back to Appendix J.
Okay, cool. Separate, inventory, catalog, and thoroughly document assets before putting them into a trust. Some trust organizations need a joint property agreement completed and notarized before accepting from a married couple any assets into an irrevocable trust. This is because joint or community property laws supersede an irrevocable trust. Both partners need to agree to put together a trust for their children. If either one of them backs out, the trust creation stops. There are 41 states still recognizing common law marriage where each partner keeps personal assets. Even in this case, we feel a formal separation needs to take place prior to placing assets into a trust. In one incident, the wife shared in the trust creation and signed the joint property agreement as part of the formation. The trustee did not leave that agreement with her, but kept it in the trust books. The wife had the trust books at the time she decided to divorce her husband. To add to the complications, the wife's family wealth allowed the parents to hire a team of lawyers. After the judge looked over the trust document, he refused to have the issue brought into the courtroom. He wanted nothing to do with destroying an irrevocable trust. Even without the joint property agreement, he could see the trust was legitimate. Although there was no legal reason to do so, the trustees eventually, after several months, gave in and signed the property back to the wife. Had the first trustee involved kept a copy of the joint property agreement in her possession, and had the trustees not been willing to give in, they could have kept the property for the beneficiaries. Further, the judge's decision gave the trust the dominant position. The property would have remained in the trust. Because the trustees did not fight, the beneficiaries were the ones who ultimately lost. The emotional issues surrounding assets in a trust can be explosive. This is why keeping exceptional documentation and accounting details up to date is essential. Training the trustees establishes confidence in their position with the know-how to protect the generations to come. And that's it.
Okay, I'm trying to find.
Really, I thought that was interesting. So if they had a trust set up and wanted to divorce, right?
Right.
And they decided, well, we are not going to break up the trust. I mean, it would almost be like, okay, then maybe you should stay married if you want the benefit of the trust or something. I mean, it would be.
Well, it appears that the wife had the copy of everything, but the trustees never had a copy of the trust, which is a big fail on the trustees' part. And the judge didn't want to get involved because it's irrevocable. It's like he couldn't, because it's irrevocable. There's a reason it says irrevocable. And so had the trustees demanded that the wife's copy be given to them, then the beneficiary, that trust could still be in play, and the beneficiaries, which I'm assuming possibly maybe was their children, if they had any, I don't know, but yeah, the trustees gave up way too easily.
But that was they should originally have had copies. Is that the issue? They
should have had copies of everything, and that way there'd be no question. The trustees would be like, well, sorry, this is what it says in the trust. But right, because they didn't have the copy, that they were just like, oh, okay, well, I don't want to fight with the wife. I don't want to, do whatever, because I don't even know what's in the trust because I don't even have a bloody copy of it. So,
but the judge didn't even want to get involved. The judge was like, nope, I don't want to touch this,
Yeah.
Interesting. Protection.
Interesting. Yeah. All right. So presentation 5 is the marriage license and the state. When you get a license to marry, the state becomes a third party to the action. In this court case reference, the state also claims to be a guardian of the marriage couple's morals. Further, a marriage license was originally created for interracial marriages when those of the white race wished to marry those of the black race. That makes sense because it was illegal, and licenses are used for things that are illegal in the government's eyes to be legalized. So that's interesting. I didn't know that.
Words, essentially. Words.
Yeah. In our history, this is due to the status on citizenship. In Black Law, 4th edition, we find this definition. Marriage license, a license or permission granted by public authority to persons who intend to intermarry, usually addressed to the minister or magistrate who is to perform the ceremony, or in general terms, to any or authorized to solemnize marriages. By statute in some jurisdiction, it is made an essential prerequisite to the lawful solemnization of the marriage. Black's law goes on to state that intermarriage, quote, in the popular sense, denotes the contracting of a marriage relation between two persons considered as members of different nations, tribes, families, etc., unquote. Although the person who originally wrote this has remained unknown, we feel it is important, especially when a marriage involves a trust. As mentioned in Chapter 16, marriage is a business venture. Herein lies the ultimate truth of that statement. State involvement. Would you rather have that business venture with or without the state involved? Using a trust to hold assets for the children provides a secure resource for them. This should be an eye-opener and another testimony to the twisted reality under which we live. The following document has been edited. Enlightening Conversation with a Marriage License Bureau. Author unknown. About 15 years ago, my former wife of about 26 years filed for divorce. We had 7 children, 5 daughters and 2 sons. At the time, I prepared a counterclaim to the petition for dissolution her attorney filed in domestic relations court. Marriage license implications. I met one afternoon with the head of the Maricopa County Superior Court Marriage License Bureau in downtown Phoenix. A young woman about 25 years old headed the Marriage License Bureau. I asked her to explain to me the general and statutory implications of the marriage license. She was cooperative and called in an assistant, a tall black man who, at the time, wrote a manual for internal departmental use. Common law states. She deferred to him for most technical explanations. He walked me through the details of the marriage license as it works in Arizona. He mentioned marriage licensing is more the same in the other states, but there are differences. Arizona is one of 8 Western community property states. The other states are common law states, including Utah, except for Louisiana, which is a Napoleonic code state. Secular and God. He then explained some of the details of the marriage license. He said, first, the marriage license is a secular contract between the parties and the state. The state is the principal party. In the secular contract, the husband and wife are secondary or inferior parties. The secular contract in a 3-way contract between the state as principal and the husband and wife as the other 2 parties in the contract. He said, in the traditional sense, a marriage is a covenant between the husband and wife and God. But in the secular contract with the state, reference to God is a dotted line and not officially considered in the secular contract. He said, if the husband and wife wish to include God as a party in their marriage, that is a dotted line, they added, in their own minds. He repeated, the state's marriage license is strictly secular. He said further, God being a dotted line means the state regards any mention of God as irrelevant, even meaningless. He said, in the traditional religious context, marriage is a covenant between a wife, the husband, between the husband, the wife, and God, with husband and wife joined as one. This is not the case in the secular realm of the state's marriage license contract. The state is the, quote, principal or dominant party. The husband and wife are merely contractually joined as business partners, not in any religious union. They may even be considered, he said, connected to each other by another, quote, dotted line. He drew a picture of a triangle with the state at the top and a solid line extending from the appendix down the left side to the husband, and a separate solid line extending down the right side to the wife. A dotted line between them merely showed they considered themselves to have entered a religious union of some sort that is irrelevant to the state. Marriage license secular contract diagram. State. is the primary party, husband and wife is a secondary party, God is a secondary party. The state recognizes these religious overtones of the marriage as a state official or a minister of a religion most solemnized it. Deputized to perform the marriage ceremony, the clergy or state representative returns the signed and completed marriage license to the state. Marriage is a business enterprise. The assistant reiterated marriage is, quote, strictly, unquote, secular to the state. It is a privileged business enterprise, so various tax advantages and other political privileges attached to the marriage license contract that have nothing at all to do with marriage as a religious covenant or bond between God and a man and a woman. Principles of community property. To get more clarity on this subject, read a legal treatise on marriage, Principle of Community Property by William Defunct. Community property law descends from Roman civil law through the Spanish codes, 600 AD, written by the Spanish jurisconsults. In this footnote says, this arose when the Moors occupied Spain. The jurisconsults were not judges. They were men skilled in the I know I'm slaughtering that. Sharia. Oh, duh. Or Islamic law, empowered to settle disputes provided both parties agreed to be bound by the decision. This is similar to mediation. In the civil law, the marriage is a for-profit venture or profit-making venture. This is true even though it may never produce a profit. When the wife goes to the local market to buy foodstuffs and other supplies for the marriage household, she restores the stocks of the business. To restate in the civil law, the marriage is a business venture. Also, as children come into the marriage household, the business venture has borne fruit. Privileges. Now back to the explanation by the Maricopa County Superior Court Marriage Bureau's administrative assistant. He explained every contract must have, quote, consideration. The state offers consideration in the form of the license itself, the piece of paper, the certificate of marriage. The other part of consideration by the state is, quote, the privilege to be regulated by statute, unquote. He added this privilege to be regulated by statute encompasses all related statutes and all settled court cases. This includes all statutes and regulations in the years following beginning the marriage. He said, in a way, the marriage license contract is a flexible, ever-changing contract as time goes along, even though the husband and wife do not realize that. Can it be a true contract if the state fails to make full disclosure of the terms and conditions? A true contract is entered knowingly, intelligently, intentionally, and with informed consent. Otherwise, technically, there is no contract. Contract iniquities. Another way to look at the marriage license contract with the state is a contract of adhesion. This is a contract between two disparate, unequal parties. Again, a flawed contract. This is also known as, quote, specific performance, unquote, contract because of the privileges, duties, and responsibilities that attach. Consideration of the husband and wife is the fee paid. This is the, quote, implied, unquote, agreement to be subject to the state statutes, rules, and controls. This includes all court cases relating to marriage law, family law, children, and property. He stressed this contractual consideration by the bride and groom places them in a definite and defined by law position, inferior and subject to the state. Few people realize this. Children belong to the state. He also said children born to the marriage are by law, quote, the contract bearing fruit, unquote. This means the children primarily belong to the state. It is important for parents to understand two doctrines fixed in the United States during the 1930s. The first is the doctrine of parens patria. The second is the doctrine of in loco parentis. Parens patria means, quote, the parent of the country, unquote, or to be blunt, the state is the undisclosed true parent. Along this line, in 1930s, Arizona's Supreme Court case states parents have no property rights to their children and have charge of their children during only good behavior at the sufficiency of the state. No court case reference is given in the original article. This means that parents may raise their children and keep custody of their children as long as they do not offend the state. If they displease the state can step in and exercise its superior status and take custody and control of its children. The parents are only conditional caretakers, thus the doctrine of in loco parentis. Ownership. He also added a few more technical details. Quote, the marriage license is a continuing contract with the state. Technically, the marriage license is a business license, allowing the husband and wife in the name of the marriage to enter contracts with third parties and contract mortgages and debts, unquote. They get car loans, home mortgages, and installment debts in the name of the marriage because it is not only a secular enterprise, but a privileged business enterprise as well as a for-profit business enterprise. The marriage contract gets property throughout its existence and over time. The hope is the property increases in value. Children. Also, the marriage contract bears fruit, quote unquote, by adding children. If sometime later the marriage fails and a, quote, divorce, unquote, results, the contract continues. The, quote, divorce is merely a contractual dissolution or amendment of the terms and conditions of the contract. Jurisdiction in the state over the marriage, over the husband and wife, now separated, continues over all areas of the marriage, over marital property and children brought into the marriage. This is why family law in the domestic relations court calls divorce a dissolution of the marriage, because the contract continues in operation, but in amended or adapted form. He also pointed out the marriage license contract is, quote, one of the strongest, most binding contractual relationships, unquote, the state has on the people. The heat of the moment. At the end of our hour-long meeting, I humorously asked if other people asked the questions I did. The assistant replied that in the several years he's worked here, worked there, he was not aware of anyone else asking these questions. He added he was glad to see someone interested in the legal implications of the marriage license and the contractual relationship it creates with the state. His boss, the young marriage bureau department head, stated, quote, you have to understand that people who come in here to get a marriage license are in heat. Their last interest in technical, legal, and statutory implications of the marriage license, unquote. Civil War. I hope this is helpful information to anyone interested in getting more familiar with the contractual implications of the marriage license. The marriage license, as we know it, did not come into existence until after the Civil War. It did not become standard practice in all the states until after 1900, becoming firmly set up by 1920. In effect, the states or governments seized or took over control of marriages in secular form, and in the process declared common law applicable to marriages abrogated. Well,
that's really good.
Yeah, right.
And I like the part about they come in, they're in heat, so they don't really care. Very good. So true. Oh my gosh. That's good. Well,
yeah. I mean, I knew that it was, licenses are only given to things that are otherwise illegal in the government's view. So why are we getting marriage licenses? It is a union between man and woman through God, not through government.
You don't have to get a marriage license, but most people think they must.
You think they need it.
Mm-hmm.
And all you need to do is basically just do an announcement in a newspaper, make sure you save that clip, and then put it in a family Bible. That is it. That will work to show like exact. I don't know. To me, a marriage license is just giving the state another thing to control in your life.
Well, you'd have them. You do what you say, but also set up a trust. The trust is pretty
Yes.
powerful, you know.
Yeah, you set up the trust and the marriage through the trust.
Marriage trust, right? Yeah,
But
that's
you don't go through the state, because I did not realize that's another key to giving control to the state for your children.
absolutely. Of course, they already have control because the birth certificate, you know. So,
What were you going to say, Justin?
Here on Florida, even when you do buy a marriage license, like I did when I was young and dumb, but they all go into part of it. Whenever you pay for it, goes into a trust. Then that makes you an investor in the trust, where you can take control of some of the things.
well, Pastor was talking about. Are you in the class? You're not in the class, are you? But he was saying how a divorce could be handled totally differently because of that trust relationship with the state.
Hey, you can handle it all in chambers out of the public and have everything wiped out, and even collect on it if you know how. But I'm still learning.
Yeah.
And that's scary, though, to say even a divorce doesn't break the contract, the state's contract. It just amends it.
Well,
You
it's just
gotta
like
have the judge put in an order to expunge the record.
Yeah.
wow, that's just like a bank account never closes, or a contract. What contracts never end, or something. I mean, it's like there's so much that goes on that we don't know about.
I mean, for the pure fact that if you have kids, that would be a main reason for me, if I were like married, to get it expunged. I don't even know, like, does divorce just put you in another category, or do you just go in saying, I want this marriage expunged from the record? I did not realize it was not, because you can go in there and say, look, this was not full disclosure. You guys set me up to do another contract with you. And so I want to terminate this contract due to the fact that I was not fully informed.
Ignorance of the law is no excuse. You know, we're supposed to know everything.
Yeah, and they can always throw it in your face and say, well, it was in the writing right here. It's your fault you didn't do the research. But if it was undisclosed, then you could still get by on it.
Yeah.
The thing is, though, is you kind of got to ask, has everything been presented that I need to know about?
Yep. That's crazy, man.
How about just rescissioning that contract?
Yeah, I mean,
Because you
once you
can.
discover it,
Well, we know it. So get the
mistake.
marriage certificate or application and rescission it. Just thinking.
That would be another way to do it. Yep. Because you got to look at it as though it's a contract. So just say, look, we need to nullify or rescind or something because new information has come to light.
The thing I'm doing mine a little different. Like, I have my marriage license, so I never got divorced. I've been separated for almost 25 years.
Wow.
But I'm having my marriage license authenticated, and I'm going to put my stipulations on the part that gets attached to it, and then put that back on there.
Stipulations like what?
Like that I'll take control that is my contract and not theirs.
Okay.
And, that I would like to see all the investments to the trust that have been made since the license was renewed or whatever.
There you go. Take control of the of the investments. Yeah. We have so much to learn about what we've entered into in all these agreements that we've made. Oh my gosh.
Yeah.
Wouldn't that be a counter offer to the contract if you do something like that, the authentication?
Well, yeah, in a sense, it would be a counter offer, but it's coming if they attach everything the way I send it in, then they've allowed it because it's their superiors that are doing it.
Right. Because they're the ones that are creating the contract.
Right, but you signed the contract. Like, if you're married, you both signed it. Have we ever actually read it? I myself can tell you I never did read it.
Right.
So
Right.
isn't that's ignorance of the law is not,
Yeah, but the one who wrote the contract, or the one who didn't write the contract has more of an advantage than the one who did write the contract. So you've got to look into contract law and find out how to nullify or how to cancel out contracts that you no longer with.
You can rescind the contract.
Okay. So that's the thing, is you can write up a rescission and say, I have recently discovered things that were not known to me before. And the biggest thing with that is through the UCC laws is that it's got to be within 72 hours. So you can pay. I found out yesterday that I had read through some documents that I was not aware of to begin with. So I've made a terrible mistake, and I am here to rescind this complete and whole contract.
Right. Mistake is powerful in the law. You can claim that you made a mistake and correct things.
And ask for forgiveness, right?
I mean, because we did a contract too. We've been doing contracts that we didn't understand. And we're able to rescind those contracts because new information has come to light. So why can't you do that with a marriage?
If you give good enough reasons why the contract was unconscious.
No, you made a mistake. You made a mistake. That's a reason.
Everything is contract. We're in here right now making contracts without realizing it.
So true. So for those that weren't here in the beginning, we're going to continue reading because on Mondays, we're going to, on Christmas night and New Year's Day evening, we're going to keep the reading going. If you can't make it, totally understand. I'm going to record them and everything like that, but I don't want to miss 2 weeks, especially when there's all these appendix things that are very interesting and very needed that we have to go through. So we're only getting it through about 2 chapters per reading. So I don't want to not read for 2 weeks. Were you going to say something, Judy?
Nope. I appreciate continuing it through the holidays. That's good.
Yeah. So, and then January 8th, we're having that guy Howard come over. So, get your questions ready. And if you could, please, just submit them to me to make sure that these are not questions that are super simple that have already been answered through the book. And that we're not double duplicating our questions to him. He's only going to be here for an hour.
Why is he willing to do that? Is it just being generous?
Joe reached out to him and told him what we're doing and asked if he wouldn't mind coming on for a little Q&A. And he was like, yeah, sure. Why not? He even asked for the what do you call it? The recordings for volume 1, because he said he's gonna upload them to the website, his website.
Maybe we can get him to come back more than once, Dawn, if he works out well. Like if
if it works out
willing.
well.
Yeah, I think that would be great, because as we keep reading, we're going to have more questions. And, I'd like to ask him about other trusts too. Like, does he know about other trusts? Or is this, the golden? I don't know.
Well, I mean, there's a gazillion, million, well, not million.
No, I understand. But my question to you is, would be to him, because this is a private trust, but I'm sure there's other private trusts. Why is this one superior to the other ones? You know what I mean? Like, I would like to know.
Sure, when you're asking him, just say, "Can you give me your opinion?" Because
absolutely,
he's very much like, I don't give legal advice.
Yes,
and he was freaking out about that a little bit. I'm like, no, we don't want your legal advice. We just want, kind of your opinion on what you think about a certain question.
Yeah. Okay. Sounds like a plan.
Yeah. But so, and then don't forget Wednesdays, we're going to keep the Wednesday readings going for the Constitution thing. So anybody have anything else they want to ask or bring up?
I have a question. So I received an email from Jasmine, and she was basically saying that it's a bulk email.
Wait. I'm going to stop the recording.